Good evening to the International Human Rights students. Karibu sana. Welcome to the class of the virtual. And today that I already posted in the morning that I am going to deal the European Court. Yes, please read what I posted on the screen. Anyone can unmute and read. Good evening to the students of the International Human Rights Law. And here the figure which is shown over there, image, is the European code which is there in the Strasbourg, France. The code is identifiable across the world by the symbol of the building in which it is housed, the Human Rights Building. 47 judges and about the 650 registry staff work there to ensure respect for the human rights of the 820 million Europeans in the 47 member states of the Council of Europe that have ratified the convention. So the members is the 47 countries, and from each country one representative would be there, but when they act it, they don't represent their country, they act independently. Yes, the Professor Dr. Mohammed Saheb Hussain and is the course coordinator, and this is the same building which I put it over there, but without writing any explanation for that one. Now, without wasting the time, let us see that what the court, how it functions, what are the members are there, and what are the works it will done. So let us see that. Yes, participants, can you read that what I posted on the screen? European Court of the Human Rights, questions and answers. And this is the building of the human rights, which is in Strasbourg, France. And questions and answers, that and, equivalent is and, but in Latin terminology, and this symbol is called ampersand, A-M-P-E-R-S-A-N-D, ampersand. Now let us see that what is the European Court of Human Rights. So let us see that the European Court of Human Rights is an international court based in Strasbourg, France. So it is international court for the Europeans, 47 countries, and which is based in the Strasbourg, France. It is consisting of the number of judges equal to the number of the states of the Council of Europe that have ratified the Convention for the Protection of the Human Rights and Fundamental Freedoms, and currently 47 states are there. So they are the states of the Council of Europe. The court's judges sit their individual capacity and they don't represent any state, even though they are from each state one, but when they collectively sit over there, they will sit as independently but not representing their state. In dealing with the applications, the court is assisted by a registry consisting mainly lawyers from all the members of the states and who are also known as the legal secretaries. For each state, there would be a registry is there, and they are set with the legal secretaries. They are entirely independent of their country and of origin and don't represent either applicants or the states. Even though they are from the different countries, from each country they will come out, but they act independently, but they don't represent in the cases where either for the applicant side or from the state side. So that is the thing which I want to share with you. Now let us come to what is the European Conventions on Human Rights. When you say the European Convention on the Human Rights, the European Convention on the Human Rights is an international treaty which only member states of the Council of Europe. See here they say member state of the Council of Europe. That means Council of Europe is different, the European Convention is different. May sign. The convention which established the court and lays down how it is functioned. Certain list of the rights and guarantees which the state have undertaken to respect. So these are the things would be there. Through the conventions only, the court will be established over there, and the Council of the Europe members, total 47 members are there, and the 47 members, they will send their representative as a judges, and they will send their representative their registry members as a registry, and they are called as their legal secretaries. So what does the European Court of Human Rights do? What is the function of it? What does it do? The court applies the European Conventions on Human Rights. Its task is to ensure that the state respect the rights and guarantees set out in the convention. Means all the member states should have to follow the convention articles. It does this by examining the complaints known as in applications. Suppose the applicant has given an application from any one member of the states and lodged by the individuals, either a case will be lodged by the individuals or sometimes by the states, or where it concludes that a member of the state has breached one or more of these rights and guarantees, the court delivers a judgment finding a violation. The judgment are binding. The countries concerned are under an obligation to comply with them. And this European court is the decision is, the judgment is, the adjudication is a binding one. And every member state should have to follow those who are the members for this convention. Okay. Now, can anyone unmute and read what is, yes, what is given over here? Okay. When can I apply to the European Court of the Human Rights? When can I apply to the European Court of the Human Rights? You may lodge a complaint and an application with the court if you consider that you have personally and directly been the victim of the violation of the rights and guaranteed set out in the conventions or its protocols. The alleged violation must have been committed by one of the states bound by the convention. So, it is an individual or an organization, the NGO, the states may represent the case and file an application if anyone violations of the human rights is there in the member states. So, what are the rights are protected by the conventions and its protocols? The following rights in particular are protected. Number one, the right to life. Number two, the right to fair hearing in civil and criminal matters. Number three, the right to respect of a private and family life. Then comes to the number four, freedom of expression. Number five, freedom of thought, conscience, and religion. Number six, the right to an effective remedy. Seven, the right to the peaceful enjoyment of the position. And the last one is the right to vote and to stand for election. So these are the rights which are more or less protected by the conventions and protocols. Can anyone unmute and read that what is which I highlighted here? Participants, are you present? Please read. I think there is a problem of internet. Okay, now let us see that. The following in particular are prohibited. What are the prohibited? Number one, torture and inhuman or degrading treatment or punishment. Okay, number two, arbitrary unlawful detention. Number three, discrimination in the employment of the rights and freedom set out in the convention. Four, expulsion or denial of entry by a state in respect of its own nationals. Next, the death penalty. The last one is the collective expulsion of aliens. So these are the prohibited under the protocol. So conventions and protocol, both the things. If any violations would be there, yes, one individual and who is a victim can file a case in the European Court of Human Rights, which is there based in Strasbourg in France. What conditions do you have to satisfy the lodge an application? So what are the conditions should be there to lodge an application? Here, complaint. What are the conditions relating to me personally? Of course, it is made by this commission itself on the question and answers so that we could know that how it functions. Number one, you don't need to be a national of one of the states bound by the convention. So you don't need to be because you are a human being enough. The violation you are complaining of must simply have been committed by one of these states against a person within its jurisdiction, which usually means on its territory. So, number one, you don't need to be a nation of one of the states bound by the conventions. From the 47 nations, you need not belong to one of the nation, because if you are just your fundamental, your rights are violated over there as I enumerated in the 8, and you can file a case even though you are not a nation of any one of the country with those who are the members of this convention. The violation you are complaining of must simply have been committed by one of the state against a person with its jurisdiction, which usually means in its territory. The person who is a member of the state has committed such a thing, and that is enough. One can file a case against the person and who belongs to one of the territory of the state, and the state is a member of the convention. And next point is okay, you can be a private individual or a legal entity, such as a company or association. Either you are a natural person or juridical person. Means you will be considered as a legal entity like a company or a association. Then you must have directly and personally been the, yes, you are, yes, you must have directly and personally been the victim of the violation you are alleging. You can't make a general complaint about the law or measures. For example, because it seems unfair, not can you complain on behalf of those other people unless they are clearly identified and you are the official representative. So it clearly says that you must have directly and personally have the victim. Either directly or personally will be the victim of the violations you are alleging and you are making the application. You cannot make a general complaint. A general complaint you cannot make it, but you should be a victim. And about a law or a measures, for example, because it seems unfair, nor you can complain on behalf of other people unless they are clearly identified you are their official representative. Unless until that you will be clearly represented, they are the official representative. At that instance, yes, a complaint can be lodged by such a group. So now now the question comes, sir, can NGOs will file a case on behalf of the victim? If the victim represents that the NGOs is their NGOs and they want to fight for that one, I believe that yes. Answer is yes. Are there any procedure that must be followed beforehand in the national courts? Yes, when a person will be there, that generally we will read in the African Charter, African courts, that is the Human Rights People's Court in Arusha, that exhaust the local remedies. That is clearly mentioned at that time. Let us see here. Yes, you must have used all the remedies in the state concerned that should provide you a redress for the situation you are complaining about. The usually will mean a application to the appropriate court followed by an appeal where the applicable or even a further appeal to higher court such as the Supreme Court or the Constitutional Court or the Court of Appeal. What it means? Exhaust the local remedies, municipal remedies of the nation. Then only you can approach to the European Court. Next, it is not enough merely to make use of these remedies. In so doing, you must also have actually raised your complaints, the substance of the convention's violations you are alleging. So, not merely the remedies would be there, but you have to show that a substantial violation of the provisions or articles of the conventions or the protocol is made. Next, you have only 4 months from the date of the final decision at the domestic level, means national level. Generally speaking, the judgment of the highest court, either the High Court or the Court of Appeal in Tanzania. In other countries like India, it is the High Court or the Supreme Court of India. To lodge an application, after that period, your application cannot be accepted by the court. So the law of limitation which is given over there is after the final conclusion, judgment of the final court, appellate court or appeal court, 4 months time would be given over there. Within the span of the 4 months, you have to file a case to the European Court. Is it clear? Participants? Okay. Now let us see. Against whom can I lodge an application? To whom, against whom can I lodge an application? So answer is against one or more of the states bound by the convention, which in your opinion have within parentheses through one or more acts or omissions directly affecting you or violated the European Convention on the Human Rights. So against one or more of the states, suppose if a person has violated it and made the victim to another person, even though he is not a member of any one of the state to the party to the convention, or that country means state, bound by the convention, in your opinion, through one or more acts or omissions directly affecting you. If the omission is concerned or act is concerned, there is a violation of the European Convention on Human Rights is there. Yes, we can bring an action against the individual or the state which is a party to the convention. Yes, Karibu Sana Sakina, can you read this one? Is it visible to you? Sakina Paul, are you hearing me? Are you
Yes.
hearing me? Tell me,
Yes, Prof.
can you read which I highlighted on the screen? Is it visible to you? Answer.
Which part, Prof?
Visible, not visible. Visible or
What,
not
Prof?
visible? Answer.
Prof.
No, you are not giving the answer. Okay, no, doesn't matter. I will read. The act or omission complained of must be attributed to one or more public authorities in the state concerned. For example, a court of an administrative authority. So, whoever may be done, either an administrative authority or the court, not the court, or the individual or any person who has violated it, naturally action will be taken. Either the action is concerned or omission is concerned, must be attributed to one or public authorities. The person, those who are public authorities in the state, concerned, for example, a court or an administrative authority. So there would be a public authority would be there to and which will made you to suffer, then you can bring an action against them. The last one is the court cannot deal with the complaints against the individuals or the private institutions such as the commercial companies. When the matter comes to the commercial companies or the individuals and the commercial transactions are concerned, but it's not the violation of the human rights. Now, who can may application be about? That means, what can my application be about? Your application must relate to one of the rights set out in the European Convention on the Human Rights, either the European Convention on the Human Rights or the members' protocol. Alleged violation any may cover a wide range of issues such as a torture and ill treatment of prisoners, lawfulness of detentions, shortcomings in civil hearings and criminal trials, discrimination in the exercise of the convention's right, parental rights, respect for the private life, family life, the home, and correspondence restrictions, and expressing an opinion or imparting or the receiving the information, or freedom to take part in the assembly or demonstration, expulsion and extradition, confiscation of property, and expropriation. So these are all the offenses where we can bring an action against because this comes under the human rights violations. You cannot complain of a violation of any legal instrument other than the European Convention on Human Rights. Whatever the article says under the European Convention on Human Rights, on those articles only, if there is a violation, you can make it out. Number one. Number two, if the member state protocols are there and the protocols they did not observe or they omitted it, excuse me, in that case also you cannot bring an action against those who violated it. Such all the Universal Declaration of Human Rights are the Charter of the Fundamental Rights. So whatever the convention says, all the articles in it and the Charter of the Fundamental Rights, even the member state protocols also will be considered. How should I apply to the court if I consider myself to the victim of a violation of the convention? So number one, by sending a completed signed application form to the court, The form, together with any relevant accompanying documents, supporting documents, must be sent by post to the following address. So there we studied in the African court, either you can send by email or telex or fax or by post, you can send the complaint to the court. So address is given the registrar, European Court of the Human Rights Council, the Council of Europe, and of course 67075 Strasbourg, Sedax in France. That is where this code is situated, based. So you may write in one of the court's official language, and here the official language is English and French. Yes, what we studied the language which are allowed there in the African courts, that African Court of the Human Rights and Peoples. How many languages are allowed there?
4 languages:
Yes, what are they?
English, French, Portuguese, and Arabic.
Very good, appreciate. But here in the European, only two languages are used over there. Number one, English. Number two, French. So in an official language of one of the states that have ratified the conventions. So in that way that we can make it out. Suppose they ratified the convention by the English, they can send by the English. If they ratified the French, they can make it by French. Now another question that I would like to ask, which is the last nation or state joined in the European Union? Yes, it's once withdrawn. Before it was there, but withdrawn, but later on joined. If you know it, you tell me. If you don't know it, you say pass on.
Pass on.
It is Morocco. Earlier it is joined, but because some other country has recognized over there, says Sadaka, something like, so they withdrawn, but later on it is joined Morocco. Morocco is the English speaking country or the French speaking country? If you know it, you tell me. If not, you say pass on.
English.
It is a French speaking country like Sierra Leone and sometimes Congo also, DRC. So it's the French. And Morocco, of course, later other language is Arabic, because it's a Muslim country, if I not be mistaken. Yeah, no purpose is served by sending the application from a fax. Excuse me. No purpose is served by sending the application by fax, since this will not interrupt the running of the period laid down in the convention for applying the court. Only the original application form sent by the post will be considered by the court. So they say no fax, even no email also, because the original application form sent by post will be considered by the court. So that was the condition you were there. But in the African court, you can send by email, you can send by fax, you can send by post. Yes, it can be done. And next point is, don't come to Strasbourg in person to state your case orally. Your case will not be examined any quicker and you will not receive a legal advice. So no personal necessity would be there, go to the France, unless until that you want to go to the France to see it. You can send by post, it's enough. So the registry may ask you for the additional documents, information or explanations relating to your complaints. Your registry may ask you if it is. And of course, the registry will endorse you also if all the documents are there and the pro forma that you followed is very much correct. At that time, they acknowledge the document by the stamp and seal that they received the complaint and it is registered also. Suppose if it is not registered, they will show the reason also. If these documents are accompanied over there, then we will register your case. Otherwise, we will dismiss your case. So you should download the application form from the court's website, fill it in carefully and legibly, sign it and return it to the court as quickly as possible. The form must include, number one, a brief summary of the facts and your complaints. Number two, an indication of the convention right you think have been violated. what article, what provisions, what protocols are violated. And the third bullet, small word, is the remedies you have already used. What are the remedies that you use? Local remedies. That is the municipal court. Number 4 bullet is copies of the decisions given by your cause by all the public authorities concerned. These documents will not be returned to you. You only copies should be sent to them, not original. And the last bullet is your signature as the applicant and also your representative signature if you have one. If you have any representative would be there, those who wants to deal the case like the NGOs or organizations or bodies. Yes, you should have to mention them also. So next point is, if you don't wish your identity to be disclosed, you don't want that your name should be come out in the picture, you must inform the court immediately giving the reasons why you don't want to show your reason. The president will determine whether your request is justified or not. Anonymity. So they don't disclose the name over there. And then at the next is, at the stage of the proceedings, you don't have to be represented by a lawyer. No lawyer will be needed. At the stage of the proceedings, you don't have to be represented by a lawyer. If, however, you wish to apply to the court through a representative, you must complete the appropriate part of the application form. If the representative would be there, then you have to show clearly that, yes, it is going to be make the representation of my case. But a lawyer will not be needed over there because they will, based on your documents, they will decide it. What are the main features of the proceedings? So proceedings are conducted in writing. Good. You will be informed in writing of any decision taken by the court. Public hearing are exceptional. There would not be any public hearing would be there. Of course, it is exceptional, they said. Your cases will be dealt with a free of charge. No money will be charged to you. Although you don't need to be represented by a lawyer in the first stage of the proceedings, and you will need a lawyer once your applications have been notified to the government. Of course, later part that if you want to employ a lawyer or engage a lawyer or hire a lawyer, you can do so. The great majority of the applications are, however, declared inadmissible without being notified to the government. So most of the cases, majority of the applications are, however, declared inadmissible without being notified to the government. So sometimes they will not notify why it is not admissible. So it may be declared inadmissible without being notified to the government, which are respective government. So that was the thing. Next, you will only have to bear your own costs, such as a lawyer's fee or expenses relating to the research and a correspondence. If you want to engage a lawyer, okay, you can pay the lawyer's fees if you are hiring it. Otherwise, only the postal charges and the correspondence charges and the documents which you are going to accompany, which you are going to support your stand, that would be enclosed with your allegations or violations which are made under the charter or the protocol. After your application has been lodged, you may apply for the legal aid. In case that you want, you can ask for the legal aid. Legal aid is not granted automatically unless until that you ask, and awards are not made immediately but only a large stage of the proceedings. Immediately, that is, the awards will not be made it over there, but a long procedure should be followed over there. Then only the judgment will come out. Yes, it will. A copy will be given to you. What are the main stages in the process? The court must first examine whether your application is admissible or not. Okay, they followed the conditions or not. Really, there is a violation of the articles in the charter is there or protocol is there or not. This means that the case must comply with the certain requirements set out in the conventions. Yes, if the conditions are not satisfied, your application will be rejected. If you have made the several complaints, the court may declare one or more of them admissible and dismiss the others. In case if you make the many complaints, of course, some are to the mark, they follow the conditions. Okay, is that genuine? Yes, they will admit it. Otherwise, they dismiss it. If your application or one of your complaint is declared inadmissible, the decision is final and can't be reversed. Once they say dismissed, dismissed. Unless until you make a complaint with another reasonable ground, at that time they may admit it or they may not admit. But the same ground, it will be not be again reverse the dismissal order which is once passed by the court. Can you read this one? Can you read that one? Participant.
If your applications or one of your complaints is declared admissible, the court will encourage the parties, you and the state concerned, to reach a friendly settlement. If no settlement is reached, the court will consider the application on the merits. That is, it will determine whether or not there has been a violation of the convention.
Yes. Once it is admitted over there, the court will see that there will be amicable settlement between you and the government would be there or not. If they find there is no such a settlement would be there, as per the violations which are made by the member state or the person, then action will be taken by the court. And once and several times I told you, the best justice is say settlement. The best justice is say
Settlement.
very good, very good. So here also they say settlement is their word. Did you see it, settlement word?
Yes.
Good. So the party should concern here they give settlement. This is the word settlement. So now how long will they have to wait for the decision of the court? So in view of the current backlog of the cases, piling up the cases, you may have to wait a year before the court can proceed with its initial examination of your application. Some applications may be treated as urgent and dealt with as a matter of the priority, particularly where the applicant is said to be in a imminent physical danger. When such a thing would be there, that will be taken the first priority when there is imminent danger is there. Now, what can I hope to obtain? If the court finds that there has been a violation, okay, it may award you the just satisfaction, a sum of money in compensation for certain forms of damages. The court may also require the state concerned to refund the expenses you have incurred presenting your case. Okay, costs also be paid. If the court finds that there has been no violation, you will not have to pay any additional cost, such as those incurred by the respondent state. Excuse me. The respondent state, for defending the case, you need not to pay in case you fail. So, please note, the court is not empowered to overrule national decisions or annual national laws. Annul national law, not annual, annul the national laws. So, the European court doesn't have any rule to overrule the national decisions, no, or annul the national laws. The court is, because every nation is a sovereign nation. So, at that instance, even this court will not say that your decision is wrong or annul it. But if anybody is aggrieved by the state decision or the High Court decision or the Supreme Court decision or the Court of Appeal decision, yes, you can approach to the other court. The court will consider it, whether the violation is there or not. Depending upon that one, it gives its own judgment. Is it clear?
Yes.
Says the court is not responsible for the execution of its judgment. So once it is given over there, they are not responsible for the execution of the judgment. As soon as it has given judgment, responsibility passes to the committee of the Minister of the Council of Europe. So the Council of Europe is there, which will give them more power to see that the judgment will be executed, because Council of the Europe only formed this court, and the Council of Europe members will represent their members to the court, and there are 47 judges are there from the 47 countries which are the Council of the Europe members, and which has the task of supervising and executing and ensuring that any compensation is paid. For instance, domestic case law, let us presume it. If any property is attached over there, do you think the judge will go and attach the property? Say, do you think that the judge will go and attach the property?
No.
Who will attach the property? Executive machinery. Who is the executive machinery? Say police. Is it or not? Of course, a member from the court also comes with the order, but a police would be there for escort. Is it or not?
Is it?
Suppose if you want to arrest it, can the judge will go and arrest it? Or the court person will go and
No.
arrest it?
No.
Who will arrest it?
Police.
Police. Though there is here also, there is a Council of Europe will take the decision and see that decision will be made, executed. So these are the things, European court, how it can deal the cases. So still we do have some time with us. Now let us see to play one of the share content. Yes, share. I want to see which one should be played. Yeah. Listen. Are you hearing?
Like tens of thousands of people every year, you
Yes.
have to lodge an application with the European Court of Human Rights. First, make sure your application meets all the admissibility criteria, in particular that you have raised your complaint before all the relevant courts in the country concerned, and that you are within the deadline for lodging your complaint with the court in Strasbourg. In lodging your application, there are certain formalities you must comply with. Otherwise, there is a risk that the court will not examine your application. Download the application form that is available on the court's internet site and fill it in completely and without using any abbreviations or symbols. Please note that a form which is incomplete will be rejected, so make sure you follow these instructions very carefully. Fill in all the parts of this page which concern you.
Sorry, Prof. We are not getting the sound.
Or a member of your family, or by a lawyer, fill in the relevant parts of the form. It is essential that you sign the power of attorney. Specify the state or states against which you are lodging your complaint. They must be states which have ratified the convention. Here is a list of those states. Give a brief description of the facts, if possible no longer than 3 pages. Explain clearly, in chronological order, the events which led to the alleged violation of your rights. Indicate which articles of the convention you consider have been violated. For each convention article you mention, in turn, briefly explain how that article was violated. For each complaint, that is to say, each violation you complain of, indicate what action you have taken before the domestic courts and what remedies you have attempted. Make sure you state the dates of the decisions given in your case and the dates on which you were informed of those decisions. Fill in this part of the form only if you have not exhausted all the possible remedies the national legal system offers, or if you have brought a case before another international body. If you have already brought a case before the European Court of Human Rights, indicate the corresponding application number. You must send the court copies of all the relevant decisions and documents. Arrange them in chronological order, make a list of them, and number them. Do not send any originals, as no documents will be returned to you. When you have finished filling in the form, print it out, date it, and sign it, and send it to the court by post only, together with copies of the necessary documents. If your form has been correctly completed, the court will examine whether your application is admissible, and if so, examine the merits of your complaint. However, if your form has not been correctly filled in, or if you have not enclosed the necessary documents, the court will not examine it. To help you fill in the application form as accurately as possible, please read the reference documents the court has prepared to guide you step by step.
So that is about the today's how the procedure would be made over there. It is clearly mentioned, and the procedure should be followed when you want to make it out. Any case, is it clear? Is it clear?
Prof.
Say
Yes.
yes or no.
Yes.
Yes. So that is the way that you have to make the approach to the European Court of the Human Rights. And now the time it will be there. At any time it will be closed. Before it closed, that I made again the repetition that we can make it. Why was the European Human Rights Court is created? The reason is the European Court of Human Rights, that is the ECTHR, was established on 21st January 1959 with a mandate under Article 19 of the European Conventions on Human Rights to ensure that the states which sign up to the European Conventions on Human Rights stuck by their assumed obligation. They have to stick to the only the assumed obligations which are there, and that is the reason if anybody violates it, any member or the state who violates those conventions, then an action will be taken against by the court. So the court established it. So what is the composition of the European Court of the Human Rights? European Courts of the Human Rights, which is headquartered is Strasbourg in France, composed of the 47 judges, one judge elected by the each party to the European Conventions on Human Rights. The president of the court is currently Robert Spano, a judge elected on behalf of the Iceland. Does the European Court of Human Rights have a jurisdiction in the UK? The Human Rights Act also requires the UK courts, including the Supreme Court, to take account of decision of the European Court of the Human Rights, which sits in the Strasbourg. UK courts are not required, however, always to follow the decision of the court. So, if the decision followed by the Human Rights Court need not to be followed in the domestic court, but it could be executed because the Council of the Europe is there with an executive body like a police in the state. Who can appeal to the European Court of the Human Rights? Who can bring in a case to the court? The convention makes a distinction between the two types of the applications. Number one, individuals applications lodged by any person. Number two, group of individuals or company or NGOs or juridical persons, and if there is any violation of the rights are there, and interstate applications brought by the state also against the another state. If any state violate the conditions or the articles of the convention, then a one state who violated it can bring an action, can that state can be other state, those who are victim of the state action can bring an action against the state who violates such a norms. And what powers does the European Court of Justice have? The Court of Justice of the European Union and CJEU interprets the EU law to make sure it is applied in the same way as in the EU countries and settle legal disputes between the national government and the EU institutions. So when they are using it, they will use the conventions laws, conventions, articles, and the protocols, and they will see that the judgment will be given on those grounds. How do you international court protect the human rights? International human rights law lays down the obligations which the states are bound to respect. Who are the member states? By becoming the parties to the international treaties, conventions, state assume the obligations and duties under the international law to respect, to protect and fulfill the human rights. Yes, because the member states should have to follow those norms which are there in the conventions. What is the role of European Code of Human Rights? The image that is the role of the European Code of the Human Rights to promote and protection of the human right violations. The European Court of the Human Rights is an international court set up in the 1959. It rules on an individual or a state application alleging violation of the civil and political rights set out in the European Convention on Human Rights. Since 1998, it has sat as a full-time court and individuals can apply to it directly. But we read it, genocide will not come under it. Yesterday we read it, genocide will not come under it. It goes to the International Criminal Court. So what does the European Conventions on Human Rights protect? All, not 46, 47 council members. All 47 Council Europe members countries have signed up to the European Convention on Human Rights, a treaty designed to protect the people's human rights and basic freedoms. Government and parliament and the courts in each country are mainly responsible for upholding the rights set out in the conventions. Yes, government, parliament, assembly, whatever that may be the court, that country is having the type of the system of the government and they have to respect and they have to protect the rights which are given in the conventions. Is the European Court of Human Rights is the effective? Yes, effectiveness. International law scholarly considers that yes, it is the European Court of Human Rights to be the most effective international human rights court in the world because the executive machinery is there, Council of the Europe is there and it will make an action. That's why it's more powerful. The decisions are given, it will be followed. How are the judgments of the European Court of the Human Rights enforced? The Committee of the Minister of the Council, I told you no, it is having such a power. The Committee of the Minister of the Council of Europe is responsible for the enforcing the court judgment like police in the domestic law, they will implement it. States are bound by the decision of the court and must execute them accordingly. Often this means amending the legislation to ensure that the violation does not continue to occur. They will see that it will not be repeated. Are you with me? Are you following me?
Yes. Yes, Prof.
Good. So still 5 minutes would be there. It will be closed down. Is the European Court of Human Rights a part of the EU? Answer is, they say differently. The European Convention of the Human Rights is an international treaty launched by the Council of Europe. It is launched by the Council of Europe in 1950 to help protect the people's human rights and the fundamental freedoms. The Council of Europe is not a part of the European Union. It is a separate. Council of Europe is not a part of the European Union, but it is a separate treaty would be there where the member states will follow it. But and 47 countries would be followed under the Council of Europe and they made under the conventions. What is the ECHR and its enforcement system? The European Convention on Human Rights protects the human rights of people in countries belonging to the Council of Europe. That are the 47 members, those were the Council of Europe, and they are the members of the ECHR and the member states of the Council, including the UK. In the UK also they have signed the convention. It's a full title is the Convention for the Protection of Human Rights and Fundamental Freedoms. Because UK also signed it. That's why the human rights are nothing but the fundamental rights in one way, in another way. How does the Council of Europe promote the human rights? The Council of Europe promotes the human rights through the international convention, such as the Convention on the Combating the Violence Against Women and the Domestic Violence and the Convention on the Cyber Crimes.